Today I'll be speaking with Andrew Seidel, who's a civil rights and constitutional attorney with the Freedom from Religion Foundation, where he serves as Director of Strategic Response. He works to keep church and state separate, as they should be. His first book, The Founding Myth: Why Christian Nationalism is Un-American, will be out in May of 2019. Andrew, so great to talk to you. I've seen interviews that you've done, and I think that there's just so much material right now to discuss that you work on. So maybe just to start somewhere, when we talk about church and state separation, is this a concept that the average American has an accurate grasp on, or do you think that there are sort of some basics about what we mean by separation of church and state that maybe are missing from the layperson's understanding?
I definitely think there are some basics that are missing. And I would say not just from the layperson's understanding, but even from experts in this area of law. You know, we heard in Judge Kavanaugh's hearings this week how some people sometimes conflate the separation of state and church with hostility towards religion. And that's absolutely not the case. And in fact, you can't have true religious freedom, the freedom of religion, without a government that is free from religion. It's just the two cannot coexist. You have to have a secular government. It's a prerequisite for genuine religious liberty. And to me, that's the biggest thing that I think people don't understand about state-church separation, is that it protects every American.
And when you talk about that separation in terms of the infrastructure of law, there is the often discussed Establishment Clause idea of the concept of the government establishing one religion over others, or religion over non-religion, for example. But when you actually want to expand and take a deeper look at the law, what other relevant points of law are important when we think about what the foundation is for separation of church and state?
I mean, the foundation of state-church separation it's right there in the Constitution. You know, the Constitution mentions religion 3 times. Before it was amended, the only mention of it was in Article 6, which prohibits religious tests for public office. And I mean, this is actually really striking, especially for the founding generation. You know, at the time, no nation had ever divorced religion and government the way the founders chose to. In fact, our Constitution is entirely godless. It doesn't mention any supernatural being at all, which was also, you know, this unique contribution of the founding generation. And then later on, a couple years later, they had the First Amendment, which says that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And those are the only 3 mentions of religion in the entire document. And all of them are exclusionary, right? They're meant to keep religion out of government and government out of religion. So it begins and ends with the Constitution. And it's very clear if you look at that document, even just the words, you don't have to study it, you don't have to be an attorney, that the government has no, as Alexander Hamilton put it, no particle of spiritual jurisdiction, right? It just doesn't have the power to get involved in religion one way or another.
You'll sometimes hear from some people in the United States, we don't need to necessarily characterize who, that the Founding Fathers were religious, and thus you sort of have to read between the lines at this separation of church and state stuff, and that they fully intended that, okay, maybe some of these things are written into the law to prevent it from getting out of hand, but that really this is at core a, quote, Christian nation. Is that forget about the morality or the logic of it, right? Is that a legally valuable analysis, or is it as simple as what matters is what's written?
No, I mean, that's a completely flawed analysis. And actually, that's the subject of my book that comes out in May. I go through and debunk the entire idea of a Christian nation, or that we are even founded on Judeo-Christian principles. You know, both of these are flawed ideas. And you can argue about whether or not the founders were religious, whether or not they were Christian, whether or not they were evangelical Christian, you know, Jesus rose from the dead kind of Christians, or even deists. But at the end of the day, it doesn't really matter, because we know that they wanted state and church separate, that they wanted these 2 different spheres of power, and they didn't want them intersecting or overlapping. And that's why Thomas Jefferson chose the metaphor of a wall, right? This isn't a fine line that is easily overstepped. It's a wall. It's meant to be tall and strong and impregnable. And it's meant to not just benefit all of our citizens, but even the religious citizens, right? I mean, the people who benefited most from the founding generation were religious minorities, and they were very supportive of state-church separation for that idea. Catholics and Southern Baptists were among the biggest supporters of state-church separation because they were minority religions, and they didn't want the government weighing in and coercing them or even pressuring them, however slightly, into one religion or another, or benefiting the majority religion, which is certainly something we're seeing happening today.
Yeah, what do you make of, I mean, we can talk about examples of Ten Commandments at a federal building. We can talk about manger displays and some of these other notable newsworthy cases. But at its core, isn't the fact that Christmas is a federal holiday an establishment of religion? I mean, I know that it's sort of like, it's almost too obvious, and it's not a battle that I think we're going to win anytime soon, but does that count as an establishment of religion by the government?
Sure, and as someone who is on the front lines of the war on Christmas every year, I would absolutely argue that it does. I mean, the way that courts have looked at this particular issue is they've said, well, because there is a valid reason for the government to want to close. In this case, it just happens that most people are Christian. They would want to take that day off anyway. The government would essentially shut down if 70% of the workers took the day off. That is, in their minds, in courts' minds, sometimes a secular purpose behind the holiday, so they've upheld it. However, the Freedom from Religion Foundation has actually gotten laws like that struck down when the purpose is very clearly religious. So here in Wisconsin, there was a Good Friday holiday, and I don't remember the exact reason that the legislature passed this law, but it was essentially something along the lines of, we want to make sure everybody can go to church and worship. And the government struck down that, or the court struck down that holiday when FFRF brought the lawsuit because it was overtly religious.
When we talk about the Supreme Court decision on same-sex marriage, which held or affirmed that at the state level you cannot ban same-sex marriage, that was the end of one very important discussion, which was what is going to ultimately happen in terms of individual couples getting married. But it was very clearly only the beginning for a whole sort of new front in the battle against LGBT rights. And I've been talking about it since day one, which is arguing along lines of so-called religious freedom to discriminate in different ways against LGBT individuals or people perceived to be LGBT individuals, who often are discriminated against in the same way. Talk a little bit about the relatively well-funded campaigns that now are operating, and whether it's about baking cakes or employer-employee relations related to religion and some of these other fronts. How would you generally characterize what's now being used as a way to fight against LGBT rights under the guise of so-called religious freedom?
Yeah, I mean, there's so much to unpack there. We could talk about that for hours. But basically what is happening is the religious right is attempting to redefine religious freedom. And actually, a better way to put it might be that they're attempting to weaponize religious freedom. They're turning it into what used to be this shield to protect an individual's right to believe, and in some cases act on that belief in a way that wouldn't harm others, into now a way to impose their religion on other people. And we're seeing it in the Hobby Lobby case from 2014, where this massive company is using religion to impose their religious beliefs on their employers. And as you pointed out, after the Obergefell decision that equalized marriage for LGBTQ individuals, that push kind of kicked into overdrive. And what you're really seeing is the religious right trying to use God as a license to discriminate. And this is the big push that we are fighting back against here at the Freedom from Religion Foundation. We've been fighting against it since before the Hobby Lobby case. We saw this coming. We saw the attempt to redefine religious liberty coming, and we've been trying to push back against it. And finally, it does seem to be that the country is sort of waking up to this idea that, just because you happen to have a belief and it happens to be religious doesn't mean you get to act on that belief. No, they want to say, I can do this because my God says so, and it doesn't matter what the impact is on other people. But courts have never decided that. though this Supreme Court and the shifting Supreme Court, I would not put it past them. We've come dangerously close, and I think we're possibly on the verge of a seismic shift here.
One of the areas of concern to me about the shift from the conversation about can 2 men or 2 women get married at the state level to what we're talking about now, the use of so-called religious freedom to discriminate, is that one Supreme Court decision made it super clear: states can't ban same-sex marriage, period. That is it's very cut and dry in a sense, or at least relatively cut and dry. Religious freedom can be argued in so many different contexts and in so many different ways that it seems more complex to me to imagine that there can be any single decision at any level that would prevent that from being done, because you can argue it in so many different ways. Is that accurate, or could there be some umbrella solution here?
No, I think that's an excellent observation on your part. And actually, this has been addressed by the Supreme Court way back in the 1870s. They said that to allow a citizen to exempt themselves from the law because of their religion, that government could only exist in name under such circumstances. Right? You would have, the law would become Swiss cheese, where anybody who believed in any particular belief, as long as it was religious, would be able to exempt themselves from whatever law they say burdens that religious belief. I mean, that is a recipe for anarchy, not for religious freedom. And honestly, they're doing a good job of pushing that narrative. I mean, in the Masterpiece Cake Shop case, at its core, that case was about discrimination, right? I mean, it was a couple was discriminated against by a business, but the story that everybody talked about was the religious freedom of not a baker, but a bakery. And that is just amazing to me, how much they pushed this narrative and how far they've advanced it.
This is a good spot to pause with Andrew Seidel from the Freedom from Religion Foundation. We will pick up our conversation with him tomorrow, starting with, we'll get to the Trump administration, but we will start with the relationship between freedom from religion and freedom of speech, which is an increasingly popular topic, particularly in some online enclaves. We'll pick it up there. Andrew, thank you.
My pleasure.
We are continuing our conversation with Andrew Seidel, who is a civil rights and constitutional attorney with the Freedom from Religion Foundation. He serves as Director of Strategic Response, works to keep state and church separate. His first book is out in May 2018, was out May 2018, The Founding Myth: Why Christian Nationalism is Un-American. Let's pick up our conversation, if we can, Andrew, with the idea of the interplay or connection between freedom from and freedom of religion and the First Amendment. Because this is something that I think, we started part one of the interview talking about misconceptions about freedom from religion and freedom of religion and separation of church and state. There are numerous arguments that are often made by those who are de facto supporting discrimination in many cases, that what we might see, what you and I might see, or some others who have sort of the political leanings that we might have, see as discrimination among religious lines is merely the expression of speech, and that is something that cannot be curtailed. Is there a gray area when we talk about freedom from and of religion and speech, or are the limits pretty clear as to when we're talking about one versus the other?
Sure. Well, and just a quick note, the book comes out in May 2019. I think that was my fault. But I think, to your question, the limits used to be clear, but in recent, say, 2 decades, there has been a push, and this is deliberate, it's a legal strategy by the religious right to conflate religious freedom and free speech. The goal was, because free speech has been so carefully protected in this nation, and because religious liberty is really not under threat in this country, right? Especially if you are a Christian, the danger that a government which is run, how much of our federal legislature is run by Christians? You're talking 99% probably. There was no real danger to Christianity from a religious freedom standpoint in this nation. So one of the things that the religious right started doing was taking their arguments to court along free speech lines. And they did this successfully in the school context, and now they're starting to expand it out, and you saw it in the Masterpiece Cake Shop case kind of writ large. The striking thing about that case is there was no request for a specific cake that said something. They didn't actually even get a chance, this couple didn't even actually get a chance to discuss with the baker what they wanted on their cake. So he didn't have any idea of what expression he was going to have to give. So there was actually no free speech issue in that case just because of the facts. But again, they did a really great job of promoting that narrative and conflating it with the religious freedom narrative. So the lines used to be very clear, but they've done a good job from a legal standpoint of blurring them.
Yeah, and it's being done it's not being done in good faith. In other words, as you're pointing out, a good job is done because that side benefits from the blurring of those lines, and that kind of gets me to the Trump administration. Where is an organization like the Freedom from Religion Foundation most concerned when it comes to the actions of the current administration in the context of separation of church and state, religious freedom, discrimination, etc.?
I mean, that's a tough question to answer. We sued the Trump administration over their religious liberty executive order that they put out on the National Day of Prayer last year in 2017. We took them to court that same day, actually, over that. We've sued them about the White House Bible study that they have, about getting access to records to that. I think overall, probably the most alarming thing, if you care about a secular government, if you care about religious freedom in the true sense, and state-church separation, is the reshaping of the federal judiciary is incredibly alarming. If Trump and Mitch McConnell get their way, about 1 in every 7 judges on the federal bench will have been appointed by Trump by the end of the year. And that is just hugely alarming. And then, of course, there could be 2 on the Supreme Court that he'd already have appointed. So that to me is probably the biggest problem that we currently are facing, because it's a problem that we're going to have for 30 or 40 years.
So how does, we've all started to read about Brett Kavanaugh's ideas about abortion, for example, and there's a very clear link between religion and opposition to abortion. But it's more complex than that, right? The ways in which a Supreme Court justice, for decades in many cases, can influence issues of separation of church and state go way beyond whether Roe v. Wade might someday be repealed. Can you talk about the different ways in which a Supreme Court justice can impact these issues, the types of cases that come up?
I mean, absolutely, and it's virtually without limit the impact they can have. And we're actually already seeing it just with the retirement of Anthony Kennedy. Lower court judges got an idea of what type of nominee Trump would put up, and they're starting to alter their opinions. You know, in 2 of the cases that FFRF has taken, we got a cross on public land in a public park in Florida struck down, declared unconstitutional. No cross has ever been upheld as constitutional in a public park. And the same thing, there was a cross on a city seal in Pennsylvania. Both courts struck those down, but in the opinions that the court wrote, they put all this regret. They said, you know, we wish we didn't have to decide this case this way. We think that establishment clause and state-church separation, that area of law is a shambles. The court needs to step in and overturn our opinion. We're deciding the way precedent dictates, but we think we shouldn't have to. And decisions like that were unthinkable a couple of years ago. And I think had the election gone differently and appointees to the Supreme Court gone differently, I do not believe opinions like that would have been written.
So is that like a signal? Is that in the same way that
absolutely.
Apologies for what some might find to be a bad analogy, but is this sort of like we've seen white supremacists claim that even though Trump's not really saying the thing, he's signaling in a certain way where if you know the language, you understand what he's kind of getting at? Is that the same type of thing that we're seeing courts signal?
I don't even think it's a dog whistle. I think they're being very open about it. And the reason they're being open about it is because we know, for instance, what Brett Kavanaugh thinks of the wall of separation. He has specifically said that the wall of separation is a bad metaphor based on bad history. He said that basically any religious artifact in this nation, whether it be prayer before the legislature, in God we trust on our money, under God in the pledge, as long as there's a history and tradition behind it, that it should be upheld. Essentially, he's arguing that if something has been around for a long time, we aren't going to apply the First Amendment to it as long as religion's involved. And I mean, you can imagine where that would leave us in terms of slavery, segregation, women's rights. That idea that history and tradition allows us to do an end around the Constitution is ridiculous, but it's something that he has specifically And he talked about it again in his hearings, and this was just in a speech last year that he said that he is a wrecking ball aimed at the wall of separation. Is a very dangerous nominee.
That all being said, and sort of thinking about Trump and Mike Pence as well, because that sort of relates to my next question, we don't have to speculate about impeachment or the 25th Amendment or anything like that, but I have been clear that there are ways in which Mike Pence would be a bigger disaster than Donald Trump. Not in all ways, but there are ways in which he would. It strikes me that because of his ideological religious background, when it comes to the issues you work on, Pence could actually be more of a threat. Do you agree?
I think that could very well be true. If we're talking about our particular area of the law and keeping state and church separate, I do think that's probably true. You know, Mike Pence infamously signed the Indiana Religious Freedom Restoration Act into law a couple years ago, despite huge outcry and backlash to doing so. And that is what we were talking about earlier. It is a law that redefines religious liberty, and it essentially gives that license to discriminate, or it attempts to give that license to discriminate to Christians. So he would certainly be a bigger threat, I think, than Trump to state church separation, though Trump is pretty bad so far.
Last thing I want to touch on, when it comes to fighting some of these cases in court, my sense is, because most people aren't lawyers, they may not understand the sort of details on which some of these decisions can ultimately hinge. So can you give us a little bit of a sense of the spectrum of, like you mentioned, across on public grounds, or I think maybe in parks you said, has never been upheld as constitutional. That seems super cut and dry, but can you give us some examples of how sometimes it can seem as though, oh, this is obviously unconstitutional, this obviously violates separation of church and state, but that the devil sort of ends up being in the details, and technicalities or seeming technicalities can determine whether or not something is upheld or struck down?
Sure. So first, the Freedom from Religion Foundation, we are 15-1 since the beginning of 2016. In court. We are winning these cases time and time again. But when we do lose, especially before 2016, it's often on technicalities. And one of the biggest ones is called standing. And basically this means that courts are saying, you, the Freedom from Religion Foundation, or your plaintiffs, don't have an injury or an interest in this case, so we're not even going to hear the case. It's not, they aren't getting to the merits of the legal question, they're just saying, you don't even get to bring this case. A really good example, a really frustrating example, is the National Day of Prayer. And I mean, a National Day of Prayer would be, I think, to any law student, to anybody even mildly versed in this, that would seem like a state church problem, probably a violation. And the Freedom from Religion Foundation took a case on that. We won it at the federal district court level, the lowest level, and then it was appealed to the circuit court. And the circuit court said, you cannot bring this case. And if that means that nobody can bring this case and nobody can challenge the National Day of Prayer, so be it. So essentially what they did was, using jurisdiction, using this fiction of jurisdiction, they said that nobody can challenge a clearly unconstitutional law. Citizens don't have the ability to enforce the Constitution. And I mean, it's an injustice of the highest degree, but it happens all the time.
Andrew, you and the organization are doing really great work. We've been speaking with Andrew Seidel, who's a civil rights and constitutional attorney with the Freedom from Religion Foundation. The book is out May of next year, May of 2019, The Founding Myth, Why Christian Nationalism is Un-American. Andrew, thank you so much for talking to us today.
It was truly a pleasure. Thank you for having me on.